Good afternoon and welcome to the first webinar in a webinar series that Water Systems Council has put together. You will get notice 2 weeks before future webinars. I know some of the future webinars will talk about your family business transition and succession, but today we're going to talk about groundwater and the Clean Water Act, which is a really hot topic around the country today and is very applicable to the water well industry. So I will go ahead and start that PowerPoint now. And we are going to talk about the waters of the United States and talk about groundwater as a conduit. The first topic I'm going to talk about is waters of the United States. So most of you know a little bit about waters of the United States. The question here is when the EPA is requiring permits for discharge of dredge or fill material into waters of the United States, how do they determine what waters are covered? Are ponds covered? Are mud puddles covered? What wetlands are covered? Things of that nature. And first, I've got a slide on the background, some cases that have been decided. So if you could advance that two more to where there we go. There's 3 times that the United States Supreme Court has looked at waters of the United States. The first was in 1985, and that was the Riverside Bayview case. All of these cases are using the 1986 definition of waters of the United States. And in 1985, the court said that adjacent wetlands are waters of the United States. That's a wetland that abuts a navigable water. And that was a 9-0 decision, so unanimous with the court. Then in 2001, the Swank case was decided. That was an isolated water body. It was abandoned pits in a salt mine that had filled with water. And the EPA said because migratory birds visit these abandoned pits that are filled with water, and it was a fairly attenuated argument that people will cross state lines to either take pictures of those birds or to shoot those birds. And when they do that, they might buy food at a restaurant, they might buy film for their cameras, buy gasoline. Therefore, the Commerce Clause is implicated. And so the EPA said these isolated waterways are subject to the Clean Water Act. In a 5-4 decision, the court said no. That this was something that was up to the states, and then it would be stretching the constitutional boundaries to cover this under the Clean Water Act. And I should back up a little bit and say the Clean Water Act comes under the Commerce Clause power of the United States Congress. And that's why we come up with navigable water. Navigable water, of course, the boats, the ships that are used in commerce pass through those navigable waters, so it is covered. But over the years, we've learned that water quality is important, and so pollution of those navigable waters, even if it's indirectly, may impede navigation. So this line has gotten much less clear. And the line was made even less clear in 2006 when the United States decided the Rapanos case. And in that case, it involved a tributary of a tributary of a tributary, a series of ditches, streams, rivers that connected a wetland with a navigable water. And that was kind of the nightmare outcome with a 4-4-1 decision. Justice Scalia wrote the plurality opinion that prevailed. And in that opinion, Justice Scalia said that basically only wetlands that abut navigable waterways are covered by the Clean Water Act. The one was Justice Kennedy, and his decision agreed with Justice Scalia that the matter should be remanded to the lower court. And so Justice Kennedy's decision has been very important over the years. Justice Kennedy required some nexus between the wetland and the navigable water and really didn't lay out any clear guidelines. And so that's what we've been struggling with since 2006, and we've been all over the place on that. So in 2015, the Obama administration passed what is called the Obama Rule. In 2020, President Trump submitted that administration's rule to the Federal Register. It will become law on June 22nd of 2020. There is a very winding road between all of these, and I'll try to get to some of this, but I'm going to try to hit mostly the highlights. And if you look at the next slide, I'm going to start by saying what is waters of the United States under the Obama Rule. Now, I want to note that the Obama Rule has been revoked by the Trump administration. It is not effective right now. Right now, all 50 states are using the 1986 rule. As of June 22nd, the Trump rule will prevail. But I include the Obama rule because I think whoever wins the election in 2020 for the presidential election, we could well go back to the Obama rule depending on who wins that election. So under the Obama rule, and I should say that these are categorical inclusions, these are all categorically waters of the United States under the Obama rule. Traditional navigable waters, interstate waters, including interstate wetlands, territorial seas, impoundments of water identified as WOTUS, definitionally jurisdictional, and I'll talk about that in a second, tributaries of waters of the United States and adjacent waters. And I probably should have used italics on waters. The court, including the Supreme Court and the EPA and the Corps, have been kind of sloppy in my opinion. Sometimes they say adjacent waters, sometimes they say adjacent wetlands. So that could well be an issue in the future. On the next slide, I talk about what is WOTUS under the Trump rule. And it's very similar in some ways, traditional navigable waters, territorial seas, lakes, ponds, and impoundments of waters that are identified as WOTUS, tributaries, and adjacent wetlands. So notice the difference there, wetlands versus waters. Next, what is not WOTUS? And under the Obama rule, we have a very long list of things that are not waters in the United States. And what I really want to focus on here is the first one. Groundwater is not waters of the United States under the Obama rule. And if we can just go through the rest of these pretty quickly, diffuse stormwater, ditches, certain ditches, prior converted wetlands, artificial lakes and ponds, stormwater. Importantly for you guys, perhaps, groundwater recharge is not waters of the United States. Water treatment systems, that was a contentious issue. Erosional features, wastewater recycling, another kind of contentious issue. And then finally, puddles. And the Obama administration wanted to make sure that puddles are not waters of the United States. Under the Trump rule on the next slide, similar in very many ways. Groundwater, again, is the second one on the list. It is not waters of the United States. Diffuse stormwater runoff, ditches that don't fall under the definition of WOTUS. I'll pause here and say, as far as ditches, I think that I could write at least one law review article just on what ditches fall under the definition of WOTUS. You all don't have time to hear me talk about that, so I won't talk about it today. Water-filled depressions and upland are not waters in the United States. Again, stormwater control, groundwater recharge, and waste treatment systems are not WOTUS. The next slide starts to talk about some of the key issues. One of the key issues are tributaries. Under the 1986 rule, a tributary is waters of the United States, but tributaries are not defined. And I'm going to go very quickly through these cases. Under the Rapanos, Justice Scalia said that tributaries are not waters of the United States. And he went into a very technical legal argument there. Interestingly, and a lot of people haven't really looked at this, Justice Kennedy said that the 1986 definition of tributary is too broad. And so we have to look at tributaries on a case-by-case basis. The dissenting opinion in Rapanos said whatever the agency said is okay. And I want to note here what I call the spawn of Rapanos is that we have had a flood of cases, pun intended, that look at cases where we have a wetland that is separated from navigable waters by a series of ditches, streams, all kinds of channels of water. And in one case in the western United States, the wetland was 186 miles from the first navigable water. And the court said, this is the West, where distances are long, so close enough. It's waters of the United States. Under the Obama rule, all tributaries of traditional navigable waters, and this is the next slide, of interstate waters and territorial seas are waters of the United States. And so the Obama rule is fairly broad. Anything that contributes flow to any of these navigable waters is a tributary. And it can be natural, man-made, or man-altered, and we can identify it through remote sensing, mapping, or historical presence. The Trump rule on the next slide is pretty different. Under that, it's only tributaries to waters that are currently or previously susceptible to use in interstate commerce. It's only naturally occurring surface water channels, must contribute perennial or intermittent flow to waters in the United States in a typical year. So the Trump rule is much more restrictive than the Obama rule when it comes to tributaries. The next issue on the next slide is, what does adjacent mean? Only a lawyer would have to ask, what does adjacent mean? But it's important. The 1986 rule defined adjacent as bordering, contiguous, or neighboring. If they are separated from natural man-made barriers, they're still adjacent. In Riverside Bayview, the United States Supreme Court pretty much, they didn't really focus on it. They just said adjacent wetlands are WOTUS, we defer to the agency. But the wetlands there were abutting the waters of the United States. In the Swank case, they again looked at Riverside Bayview and they said these isolated waters are not adjacent, not waters of the United States. In Rapanos, it gets really ugly. Justice Scalia said it must be a continuous surface connection. In other words, it must abut. Justice Kennedy said that's wrong. If it basically has some nexus to the navigable water, any type of connection, it's adjacent. And we have to look at every single case to figure that out. And again, the dissenting opinion in Rapano said, let's just do whatever the agency says. The next slide, the Obama rule for adjacency defines adjacent as bordering, contiguous, or neighboring. And the Obama rule, and the courts have gotten a little bit in trouble for their definition of neighboring, because it really didn't go through the appropriate comment and notice period. But they talked about if it's within the 100-year floodplain of a traditional navigable water, interstate water, or territorial sea, it is neighboring. If it is within 1,500 feet of the ordinary high water mark, it is neighboring, things of that nature. So it's fairly broad. The Trump rule on the next slide narrows that down significantly to say only wetlands that abut navigable waters or have a direct hydrologic surface connection to navigable waters are adjacent. Abut means that the wetland touches at least one point or side. So that's pretty narrow. The next issue on the next slide, and now we are getting fairly contentious. Ephemeral and intermittent streams have been a big debate on waters in the United States. And that was not clear under the 1986 rule. Under the Rapanos rule, Justice Scalia's plurality said that WOTUS does not include channels of water through which water flows intermittently or ephemerally, or channels that periodically provide drainage for rainfall. Justice Kennedy rejected that and had some fairly strident language talking about how an intermittent stream could flow, hundreds of thousands of gallons a minute, even though it's intermittently, and would not be covered by Justice Scalia's rule. Whereas you could have a continuous stream that flows at a trickle for all 365 days of the year, and that would be waters of the United States. Under the Obama rule, ephemeral and intermittent streams are included as waters of the United States. So it is fairly broad and goes against what Justice Scalia said. The Trump rule, and most people believe that the Trump administration tried to mirror what Justice Scalia said in Rapanos as closely as possible. However, in the Trump rule, ephemeral streams are expressly excluded, while intermittent streams are included as waters of the United States. So the Trump rule is broader than the Obama rule, and even broader than Justice Scalia's opinion, but narrower than President Obama's rule. And groundwater gets mentioned a lot when the Trump rule talks about ephemeral and intermittent. Ephemeral streams are water that flows or pools only in response to precipitation. If the surface water flows continuously at certain times of a year, more than in direct response to precipitation, it is intermittent, and specifically mentioned is when the groundwater table is elevated and the surface water flows, that is an intermittent stream and covered under the Trump rule as waters of the United States. On the next slide, we talk about Justice Kennedy's significant nexus test, which was very problematic because Justice Kennedy defined nexus as significantly affecting the chemical, physical, and biological integrity of covered waters. So we really didn't know what that means. Justice Scalia said, no. Nexus refers to abutment. Abutment is the proxy for nexus. Kennedy is off base. Kennedy says, no, Scalia is wrong. It's more than just abutment. And we have struggled with that for years and years. So on the next slide, we see that under the Obama rule, that the Obama rule adopted Justice Kennedy's significant nexus test and said that if there is a significant nexus, that water is waters of the United States. Under the Trump rule, however, the Trump administration tried to come up with what we call a bright line rule and said nothing about significant nexus. So there is no significant nexus test under the Trump rule. The next slide talks about, case by case. What waters do we have to look at case by case? And that's only under the Obama rule, which is going to look at regional water features with a significant nexus, or if it's proximity to a floodplain or high tide line with a significant nexus, it will be waters of the United States. However, we're not going to know that until we look at each particular case. Under the Trump rule, there is no case-by-case analysis, no significant nexus test. And on the next slide, I just kind of talked about, since the Rapanos case, we've had some new faces join the Supreme Court of the United States, and what might that mean when WOTUS gets back to the United States Supreme Court, and I think it will. Chief Justice Roberts wrote in one of the opinions that he was basically scolding the EPA and said, look, EPA, this is your job to come up with what the definition of waters of the United States is. And you have really generous leeway to do that. So if you come up with something reasonable, we will go with that. But now of the people on the court, 4 of them are no longer on the court. Of the 5 justices remaining, 3 of the justices voted with Justice Scalia. 2 of those justices voted with the dissent. Justice Kennedy is now gone, replaced by one of his former law clerks, Justice Kavanaugh. So our 4 new faces are Justice Sotomayor, Kagan, Gorsuch, and Kavanaugh. Just, looking at it ideologically, you would guess that Sotomayor and Kagan would vote with the dissent. You would guess that Gorsuch and Kavanaugh would vote with what was the Justice Scalia rule. However, the case I'm going to talk about here in a minute shows us that maybe that's not going to happen. One thing that lawyers are talking about is the court says they're going to defer, but the court is coming up with their own rules. So what if the agency writes a rule that's not similar to what Justice Scalia or Justice Kennedy has said in these court cases? We don't know what's going to happen. And it's kind of interesting that the Obama rule was basically written to correspond with Justice Kennedy's decision in Rapanos. The Trump rule was basically written to correspond with Justice Scalia's opinion. Now we've got 4 new people on the court. So what does that mean? And on the next slide, I try to say, what does all of this mean for the water well industry and for the groundwater industry? And you can see on the left, it says tidal wave about to hit. On the right, Oprah is saying that you get a lawsuit and you get a lawsuit, everybody gets a lawsuit. After the Obama rule was finalized, a number of lawsuits were filed. They are still pending, but once the Trump rule is finalized on June 22nd, I assume that those lawsuits are going to be dismissed. But don't worry, lawsuit fans. On June 22nd, I guarantee you that lawsuits will be filed. And in fact, a number of lawsuits have already been filed. There are lawsuits pending on the 1986 rule, on the Trump rule. And one interesting thing is that farm groups are generally on the same side on this issue. Some farm groups have said that the Trump rule is great. We agree with the Trump rule. A group of farmers have filed a lawsuit saying that the Trump rule is too restrictive, and they have filed suit to overturn the Trump rule. So I think for the water well industry, that means more uncertainty. We're really not going to know what waters in the United States are, in my opinion, in quite a while. I mentioned earlier that I think the 2020 presidential election may have a huge impact on this. In my opinion, one of the things that is happening here is which rule will get to the United States Supreme Court first. If President Trump is reelected, I suspect that the Trump rule will go to the United States Supreme Court, and I suspect that the court will uphold it. If Vice President Biden wins the election and becomes President Biden, I suspect that President Biden would immediately repeal the Trump rule and push forward a rule that is identical or very similar to the Obama rule. And particularly if President Biden is reelected, I think that would pretty much guarantee that the Obama/Biden rule would be adopted. Again, if President Trump is reelected, I suspect that the Trump rule will become final. And then as the administrations change in the future, it's possible that this could keep going back and forth. What could change it for permanently or for quite a while would be if Congress does something. I don't see much hope of that. So I think we're going to see quite a bit of back and forth over the next several years. We might see a little stability after the next election, depending on who gets elected. But I suspect that this will be a moving target for quite a while. I haven't seen any questions yet, so I'm going to move on to our next topic, which is groundwater as a conduit. And many of you have heard about this case or this issue. The United States Supreme Court recently decided a case, the Maui County case, on the groundwater as a conduit issue, and Water Systems Council and the National Groundwater Association joining forces to file a friend of court brief in that case. I had the great privilege of writing that brief, and that brief attempted to put forth the view of the groundwater industry, the water well industry, and have our voices heard before the United States Supreme Court. So on the next slide, I have tried to summarize this rule. And again, lawyers have to define every word. The Clean Water Act prohibits the discharge of any pollutant from any point source into navigable waters without a federal national pollutant discharge elimination system permit or NPDES permit. And this case involves a lot of terms and quotes. Discharge of pollutant is any addition of any pollutant into the navigable waters from any point source. And really, I should have used more quotation marks, believe it or not, because some of the things that we argued about in this case, what is an addition? What does to mean? When you say to navigable waters, what does that mean? Sometimes it's not fun being a lawyer when you have to ask what does to mean or what does is mean. So the issue here, which was very important to the groundwater industry and will continue to be important to the groundwater industry, if we have a pollutant, and I probably shouldn't use the term discharge, but if a pollutant is placed into groundwater or makes its way to groundwater, and that groundwater is hydrologically connected to a water of the United States, such that the pollutant eventually reaches the waters of the United States, does the Clean Water Act apply? In other words, if the discharge is indirect, it travels through groundwater to jurisdictional waters, do we have to get an NPDES permit? That's really important for the groundwater industry. When you put in a water well, do you have to get an NPDES permit? More to the point, perhaps, how about septic systems? If you have a septic system, do you have to get an NPDES permit? That would add a lot of expense, a lot of time to the process, and the argument that the Water Systems Council and NGWA made in part was the states already regulate water well contractors. And so this would be an additional layer of regulation on people. So my next slide, there's a lot of confusion about this groundwater as a conduit. One thing we're not arguing about is whether there is a pollutant. Clearly, in the cases that we have, there's a pollutant. The question is, if that pollutant makes its way from a coal ash pond or a broken pipe or an injection well into waters of the United States, do you need a permit? The other thing that I said is not a question is whether groundwater is WOTUS. And I'm a little more hesitant when I say that, because in the case that eventually made it to the United States Supreme Court, the lower court, the U.S. District Court for the District of Hawaii, said that groundwater was waters of the United States in that case. And basically they took Justice Kennedy's substantial nexus test and said if groundwater is connected to the waters of the United States, then the groundwater is waters of the United States. The other issue here is if this issue is determined in a certain way, I think as a practical matter, groundwater is waters of the United States, because if a pollutant is discharged into groundwater, you're going to have to get an NPDES permit. in many cases. So I've said that this is kind of making groundwater waters of the United States through the back door. So those are some of the issues that are floating around. Yes, another pun. They're so easy with water. So let's get down to the brass tacks. What's going on here? So these cases were percolating. I love it, yet another pun. Percolating in the court system for 20 years, 25 years. But in the past 5 years or so, it started to have more of these cases, whether discharges to groundwater that made its way to waters of the United States. Is that a discharge that requires a permit? So in February of 2018, the EPA requested comments on this issue because they had previous statements on the issue, and maybe these statements were confusing and conflicting, and they wanted to know whether the agency should clarify or revise this issue. And those comments were due in May of 2018, and Water Systems Council submitted comments, as did the National Groundwater Association and a large number of others. They received a huge amount of comments on this issue. In the meantime, however, the next slide shows that there were some cases going on. And in the Hawaii case, which I'll talk about in a minute, the courts were saying, yeah, you need a permit. In the Upstate Forever case out of South Carolina, I know we have at least two people from South Carolina out there, so shout out to South Carolina. A gas pipeline burst, and the product went into the ground, and there was a stream fairly close by. But a lot of that gasoline didn't make its way to the stream for years. But a lawsuit was filed by environmental groups saying that the oil and gas company should get a permit. And mind you, this pipeline broke, and Kinder Morgan immediately repaired the rupture. But the Fourth Circuit Court of Appeals said that is a discharge, you need an NPDES permit. Kinder Morgan appealed that to the United States Supreme Court about the same time that the County of Maui appealed that case to the United States Supreme Court. The third case was also from the Fourth Circuit Court of Appeals from Virginia. And in that case, it was a coal ash pond case. And it's a weird case when they said coal ash pond is not a point source, but if it was an indirect discharge, you would need a permit. On the next slide, I show the cases that had held that you do not need a permit for indirect discharges. And that included the Sixth Circuit Court of Appeals, a Kentucky case, and a Tennessee case. And it included some lower court cases. I believe Prairie Rivers, yeah, it was out of Illinois. And then the Cape Fear case was out of North Carolina. They said, no, you don't need a permit. So now we've got Maui County. And Water Systems Council and NGWA were ready to go, waiting for the court to decide whether they were going to take the Kinder Morgan case or the Maui County case. I knew the court was meeting on the Maui County case one day, I was actually in Fredericksburg for the Virginia show. And so I'm sitting in front of my computer. I'm drooling all over the keyboard. I'm hoping that I don't, don't get an electric malfunction because of all my drool. And I keep renewing the screen. And sure enough, the court took the case. And so NGWA and Water Systems Council leapt into action. We wrote the brief, we submitted that. Oral arguments were held this past November, and I was lucky enough to be able to be there and to get a seat. And so the next slide summarizes, in my opinion, there were a lot of pretty silly analogies being made. The United States argued for a little bit of this, and the United States said that it should not require a permit, and they said it's just like if you take a bottle of whiskey, pour it into the flask, take it to a party, and pour the whiskey from the flask into the punch bowl. You wouldn't say that the whiskey came from the whiskey bottle, you would say that it came from the flask. And then the other side said, well, no, that's not a good analogy. What if you go to the grocery store and buy some groceries, you put them in your car, and you then take the groceries from your car to the house? You wouldn't say that the groceries came from your car, you would say that they came from the grocery store. And what if you ordered a package? Would you say it came from Miami or from the delivery truck? And the court really didn't like any of those analogies, and neither did I. Then on the next slide, boy, I don't think all United States Supreme Court arguments are this exciting, but this one surely was. And I think we're a couple slides behind. If we can move, yeah, there we go. So we talked about an Agatha Christie novel, and if you advance one more time, you'll see that Justice Roberts said, and he was talking about septic systems when he said this. He said, you've got 100 septic systems, and you've got pollution. You don't know which of the 100 septic systems polluted the water. So it's just like an Agatha Christie novel. Then on the next slide, I'm summarizing the argument a little bit here, where the four, what we would call liberal justices, were really concerned about evasion. What if somebody puts a pipe 5 feet from the navigable water and discharges the pollution? Under Maui County's reasoning, that would not be a discharge. And I should back up a little bit and say that what was happening in Maui County was that, and I'm getting the message that they can't hear me. I feel like I'm in a telephone commercial. Can you hear me now?
Yes, you are live. They can hear you.
Great, thank you. The Maui County case involved, Maui County had some injection wells on the beach, and they were injecting wastewater into those injection wells. And they were on the beach, so that waste eventually made its way to the Pacific Ocean. And so Maui County said, since it wasn't directly discharged, it should not be require a permit. And the more conservative justices were really worried about septic tanks and said every septic tank owner would be forced to get an NPDES permit if we accept the Hawaii Wildlife Fund argument on this. And Justice Roberts said, how about seepage versus forcefully expelled? Justice Breyer said, how about functionally equivalent? And then we kick it back to the EPA. Roberts said, I don't like functionally equivalent. It's just as vague as fairly traceable. That's what he said in the argument. And finally, Justice Thomas, and you can see from the picture of Justice Thomas, there was an argument between some friends of mine and I, was Justice Thomas asleep or not? I don't think he was, but some people thought he was. He did not ask any questions. On the next slide, finally, on April 23rd, the United States Supreme Court issued their opinion. And in short, their opinion muddied the waters even further. I call it the Goldilocks and the Three Bears decision, because the court said the argument put forth by Maui County, the test there is too narrow. It could be abused. But the test put forth by the Hawaii Wildlife Fund, it's too broad. It would cover septic tanks and everything else. So the court came up with an opinion or a test that it thought was just right. And oddly enough, it was Justice Breyer's functional equivalent test. So Justice Breyer must have convinced the Chief Justice that it wasn't such a bad test. And the majority, and it was a 6-3 decision with some really odd bedfellows. What we call the liberal wing of the court voted in favor of the majority, but they were joined by Chief Justice Roberts and Justice Kavanaugh. And Justice Breyer said this test involves at least 7 factors. At least. This is not an exhaustive list. And the 2 main factors are how long does it take for the pollutant to get from the source to the water? And second, what is the distance between the source and the water? And these are going to be the 2 most important factors in most cases, but not necessarily all cases. And then we have what is the nature of the material traveled through, the extent to which the pollutant is diluted or changed, the amount of pollutant entering waters, the manner or area in which the pollutant enters the waters, and the degree to which the pollutant has maintained its identity. Again, these are not an exhaustive list, so you can come up with other factors, but this is what the court proposed. The majority on the next slide, as I said, Breyer, Roberts, Ginsburg, Sotomayor, Kagan, and Kavanaugh rejected both tests, adopted that functional equivalent test, and I think created a lot of confusion and uncertainty. On the next slide, I talk about Justice Kavanaugh's concurring opinion, which I must say is one of the strangest concurring opinions I've ever read. He basically wrote his opinion to say, what would Justice Scalia say? Or what would Scalia do? And Kavanaugh argued that this opinion is consistent with what Justice Scalia wrote in Rapanos that the Clean Water Act is shot through with irreconcilable ambiguity. So it's not the court's fault. It's really the court trying to come up with a bright line rule. This is not a bright line rule, but don't get too panicked because time and distance are the most important. Justice Thomas and Justice Gorsuch filed a dissent, which I talked about on this slide. And this is really typical of Justice Thomas, where he said we need to stick with the text of the statute and only direct discharges should be covered. I think I'm going to do pretty good time-wise. I'm about to wrap up. On the next slide, I want to talk about Justice Alito's dissent. And Justice Alito's dissent was scathing. He said the court is making up their own rules. They're just making stuff up. And if you're going to make stuff up, you should at least make something up that can be consistently applied. Nobody knows what this rule means. The regulated community doesn't know, the lower courts don't know, nobody. Again, the Clean Water Act has a lot of ambiguity. Justice Alito, like Justice Thomas and Gorsuch, would require that there be a direct discharge before a permit would be required. And Alito again said, what about septic tanks? Do they need a permit? We don't know. What are we going to do? And so on my final slide of the presentation, I talked about what does this mean for the water well industry. And again, it means more lawsuits. The Maui County case has been sent back to the lower court. The Kinder Morgan case has been sent back to the lower court. There's at least one case where they're using the Maui County decision to settle the case. People are already saying that direct discharges to groundwater have to get a permit, period. So they're mischaracterizing what the court said. And so we don't know what's going to happen. I strongly suspect that the United States Supreme Court is going to have to hear another case. I think that's probably going to be a coal ash pond case, but it could be a septic tank case. What should you do? What should you do as a water well contractor, or if you're involved in wastewater or in the groundwater industry? All I can say is be really, really careful. I know we are, because groundwater is our life. Groundwater is our industry. If it's contaminated, we don't make a living. But you have to be even more careful. I think what is coming are citizen suits. Citizens can file suits claiming that a well contractor or anybody has violated the act. And if they win, the defendant has to pay their attorney's fees. So I think we're going to see a lot of citizen suits. And I think EPA is going to try to make some rules. When they make their rules, there's going to be lawsuits. And so I think lawyers are going to be really happy with this decision, although I'm not very happy because I don't think much was settled. And so that concludes this webinar. I want to mention that, and if you can go to the very last slide, I want to mention that you can join Water Systems Council. Go to our website for more information on that. We've got some webinars coming up on family business succession and other issues. And so please be on the lookout for those other webinars. And last, for those of you who are watching in Colorado, this webinar qualifies for one continuing education unit, and the number is 2020-01-041-A, Water Systems Council. Again, that is 2020-01-041A. And on behalf of myself and Water Systems Council, I want to thank all of you for attending the webinar today. I look forward to seeing you virtually on future webinars. And if you have any questions that you didn't ask today, feel free to contact Water Systems Council, and we will try to get your questions answered. Have a wonderful evening, and thank you so much again. Stay safe.